you're ready, you may proceed.
May it please the court, my name is John Carlson. I represent Mr. Messiha. On my right is Suzanne Brownless, who represents Mrs. Messiha. I'd like to reserve 2 minutes of my time for rebuttal. This case comes before the court from a final judgment of dissolution of marriage. And in that final judgment, it's our position the court committed reversible error in a number of different aspects. First, with regard to the classification and distribution of assets and obligations, it's our position that the lower court misclassified and distributed assets. In this regard, the court distributed to Mr. Messiha the reduction and reutilization of advances on a HELOC loan. The parties had entered into a mediated agreement which clearly authorized him to freely use the loan. The mediated agreement further provided that the balance at the date of filing would be utilized. So whether he decreased the balance, used the balance, did anything with it, they had provided this for in a mediated agreement, and that was ignored by the trial court in the final judgment. Some $12,600 involved. The trial court found that there was a German bank account, that the total amount should be allocated to the former husband as a marital asset. The total absence of any competent, substantial evidence before the trial court.
Well, counsel, wasn't the account in the husband's name?
Yes.
Isn't that competent, substantial evidence?
Not in and of itself, because the record showed how the money entered into the account from a nephew. There was nothing to show that any monies left the United States to go into that account. So there was no competent, substantial evidence that he funded the account. And monies from outside the marital efforts or labors, if it comes as a gift or it comes from somebody else, and it's not put in joint names, that's a non-marital asset. The court also determined that the utilization of certificate of deposit proceeds was a marital asset. The mediated agreement, again, gave Mr. Messiha the authority to use the account at the credit union, to freely use it, obligated him to make certain payments. The evidence before the court was that these payments ran in the neighborhood of $3,500 per month. He used the monies during the course of the proceedings to pay for the obligations set out in the agreement. Again, the agreement said he had the right to freely use this. So the court, it's our position, was in error in determining that this was in fact a marital asset to be allocated when in fact it had been used in accordance with the agreement. The trial court awarded Mrs. Messiha a corporation called SDS Corporation. She was the sole stockholder. She insisted throughout the proceedings that the corporation be given to her. It was. The trial court, however, took some of the assets out of the corporation and transferred them to Mr. Messiha. This the court cannot do. I think the law is clear in that regard. Finally, with regard to the division and the distribution of assets, the court denied any credit to Mr. Messiha for reducing the balance on the debts. What the court did was, in the final judgment, it said the date for determining the valuation of debts will be the date of filing, which is consistent with the parties' mediated agreement. On reconsideration, the court changed its mind and said it will be the date of the final hearing, which did not give Mr. Macia any credit for debt reduction. So the effect of the division and distribution of assets was to award Mr. Macia assets that had been expended, that were not marital assets, and to fail to give him credit for debt reduction. This all plays into the award of alimony by the court, because it made the determination as to the amount of alimony to be awarded before a final distribution of property. That's not following the statute. Secondly, it changed its position on a number of property distributions between the final judgment and the order on reconsideration without re-examining alimony. In the alimony determination, the lower court failed to consider the financial resources available to Mrs. Macia. For example, she had $150,000 in liquid assets. That didn't enter into the court's decision. The court failed to consider all sources of income available to Mrs. Macia.
How do we know the court failed to consider it, or considered it and just came to a different conclusion than you would have preferred?
Basically, because we argued that point on the reconsideration, and the court took the position that she was not going to consider the contributions, for example, made by the son. And the statute says all sources, and you have a situation where you have an individual that is receiving support from another individual.
But wasn't there, maybe my memory's faulty, I thought the evidence was that the son was moving out.
That's what the evidence was at the end of the lease. But this is at the time of the final hearing. He had not moved out. His intent was, yes, at some point in the future, I'll move out. That may or may not have occurred. I mean, that's speculation in the future. The court also considered automobile expenses for Mrs. Macia. I think the record is clear that nothing in her financial affidavit reflected automobile expenses, that she had given her son the use of the car, that she testified, in the future, I will have automobile expenses. I think the court has got to look at what is before the court at the time, not speculation, not conjecture as to what my needs will be in the future. What the evidence showed was that she was receiving $1,200 a month, and on that money, she was increasing the savings in her bank account. She was a very thrifty individual. She was saving money, and this is not the function of alimony. The court then gave her a 66% increase over the temporary alimony award. And when she's saving money on what she's receiving, it totally skews the ability to pay and the need. The need was not there. And I believe the court committed reversible error. Finally, summing it up, with regard to attorney's fees, where the court has, in our opinion, did not equal the playing field, but tilted it substantially to the former wife, attorney's fees would be inappropriate. Thank you.
May it please the court. My name is Suzanne Brownless, and I'm here representing the former wife, Susan Macia. I believe that...
Counsel, before you get started, you have a cross appeal on a question of attorney fees. Did you wish to reserve any time for rebuttal on the cross appeal?
I'll address my cross appeal first, Your Honor. Basically, I believe that Judge Clark, in the trial below, appropriately divided marital assets. She appropriately identified them and divided them 50-50 between the parties. That having divided them 50-50 between the parties, she considered that division in the appropriate calculation of alimony, that the $2,000 a month alimony that she arrived at is supported by competent evidence of record, that it appropriately places the wife in this 27-year marriage in a lifestyle that was maintained during the marriage. I'd point out to the court that this is a long-term marriage in which the wife, for the 9 years prior to the dissolution, was a stay-at-home mom, but who had prior to that substantially contributed to the ability of the husband to be educated and to reach the professional position that he did. I would also point out to the court that given an equitable 50-50 distribution between the parties, Judge Clark was correct to focus on the earning ability of the parties at the time, which was highly desperate. Basically, the difference between being a cake decorator at Walmart for a little bit over minimum wage to approximately $100,000 a year on behalf of the husband. That given that...
Well, address, if you would, the appellant's argument that with respect to the bank accounts and the balances of the debt, that the order on appeal is really contrary to the terms of the mediation agreement.
Yes, sir, I can address that perfectly, Your Honor. If you look at Joint Exhibit number 71, which is the mediation agreement entered into the parties on August 6, 2004, you'll see that the AmSouth home equity line of credit is specifically listed as a debt. Now, we all know that with regard to an equity line of credit, it's quite a unique debt because the equity in the home is a marital asset. However, a home equity line of credit is also a debt that decreases the equity in the home dollar for dollar when someone uses that debt. So I think if you look at the mediation agreement, you'll also see that it says that any debt that's incurred by the parties subsequent to this agreement will be their sole responsibility. And our position, and the court found, is it's clear that the husband took the $12,600 from this home equity loan in July, August, and September of 2005. It clearly was a debt. He clearly increased that debt. And by increasing that debt, he decreased the amount of equity. He certainly decreased the amount of equity that would otherwise have been in the marital home. I would also mention and note that if you look carefully at Joint Exhibit 71, the mediation agreement, it does not set a value or a date by which the home equity or any marital asset will be valued. Now, we know that the statute, 61, tells us that the date of determining whether something is a marital asset or not is the date of filing. But there's nothing in the statutes that determine the date of determination of the value of a marital asset.
Well, what does this agreement mean in paragraph 5 when it says the balances of the debts listed in paragraph 3 as they existed on the date of filing the petition for dissolution of marriage herein shall be considered marital debts? Is that the intent of fixing the amount of that for the purpose of valuation of those debts for the purposes of the final judgment?
Well, Your Honor, and I'll admit that at the time that this mediation agreement was entered into, this is the result of a 14-hour mediation session that perhaps all of the intentions were not clearly expressed. But the wife clearly testified at the hearing that what she intended to do here was to make a trade. In other words, to say at the time that this mediation agreement was entered into, the court had allowed the husband to take $5,000 from the SDS corporate account. He was the sole employee of SDS. He had a contract with Unisys. Unisys was basically paying $10,000 a month into that SDS account. All right. The court had previously limited the amount of money he had as salary to $5,000. The quid pro quo here was that Mr. Macia would continue paying the minimum payment on all of the debts listed, of which the home equity was one, in exchange for being allowed to take the balance of the SDS account after the wife's alimony was paid and after the insurance for the parties was paid, as well as other taxes that would be generated by SDS. So what I think has happened here, Your Honor, is that the intent of the parties was...
That trade-off doesn't appear anywhere, as I see it, in the mediation.
No, sir, it does not appear, but I would suggest to you that the home equity loan is specifically listed as a debt, and that the intention was not that marital assets would be fixed, but that he would pay this debt. He would pay this debt with the additional $5,000, and that that would be the trade. In other words, I do think the court had the ability to reconcile the treatment of the home equity loan as both a debt and a marital asset with the total intent of the agreement. Otherwise, Mrs. Macia would have no reason to have agreed to give her husband an additional $5,000 a month. That also goes to the counsel's argument regarding the fact that the court did not allow Mr. Macia to be given a credit, because, again, that was in exchange for payments of these listed debts. With regard to the determination of the appropriate amount of attorney's fees, Your Honor, I think that when you look at the initial final judgment, the court instructed the parties to prepare a schedule that, on the motion for reconsideration, issues were raised by both sides, that when you take the final judgment and the motion for reconsideration together and you look at the motion for reconsideration, attorney's fees were addressed again, alimony was addressed again. So I think it's a bogus argument to argue that the judge did not appropriately consider either alimony in setting attorney's fees or the equitable distribution of the assets in arriving at the amount of alimony. With regard to the attorney's fees, what I do think is not competently supported by the record is I do not think the judge appropriately considered all of the Rosen factors. Specifically, I don't think the judge considered the fact that at the end of the day, the wife prevailed on virtually every issue that she was in conflict with in the husband. I also don't think that the court appropriately considered the activities of the husband during this case. I think if you look at the record, you'll see that the husband consistently did not provide materials that he said he would. And this resulted finally in the entry of a sanction order by the court, and that's in the record in Volume 3, page 353, in August of 2005, that he made frivolous litigation arguments. For example, he litigated 4 separate times in 4 separate hearings the payment of a $20 wire transfer fee. He also litigated at one time in October of 2005 over 80 cents. So I think when you take all that into account, what the judge did not consider was that many of the hours expended in this case were the direct result of either frivolous actions taken by the former husband or of the husband's attempts to delay and frustrate the whole process. And finally, I would note in my last 60 seconds that the husband raised a very unique argument with regard to alimony, and that is considered in Judge Cooper's April 4th order. That's Volume 2, page 343, in which he advanced the theory that adultery would be relevant in this case, or the alleged adultery, because it affected gave him a heart attack in September of 2003, which then impaired his ability to earn. This required 5 depositions, 2 of the physicians, 3 of the alleged lover, the brother, his brother-in-law, and their son, on a legal point that the husband should have known was inappropriate. So for those reasons, we would ask that the attorney fees be increased and that the rest of the order be supported.
Counsel, I've got a question. Do you agree that the valuation of the proceeds in the capital city account is incorrect?
Oh, yes, sir. I think that was, I admit that. Yes, sir. It should be $5,900 and something. But I would also say, Your Honor, that with regard to that issue, For the first time on appeal, the husband is now saying the capital assets as well as the bank account is not a marital asset, whereas if you look at all of the evidence in this record and his proposed orders is attached to our appendix, you'll see that he always considered them marital assets when in fact he wanted them awarded to the wife. Thank you, Your Honor.
First, I'd like to address a couple issues raised by Judge Van Nortwick. One of them has to do with the mediated agreement. In the final judgment, and this is page 693 on the record of appeal, the court found that the parties agreed in the mediation agreement that all debts would be valued at the date of the filing, then changed the opinion with regard to that. Paragraph 5, as you clearly pointed out, does say the balances of the debts listed as they existed on the date of the filing shall be considered marital debts. It doesn't say the debts identified, it says the balances. So the issue, and it goes on to say that if you increase the balance, you're going to be liable for the balance.
So if we have taken into consideration the home equity line of credit, if either party had increased that balance, they would have been responsible for the increase in balance after the date of the filing.
After the date of filing, that's correct. But in fact, if you look at the final judgment again on the same page, the judge noted that Mr. Maciah had in fact reduced the balance. And although he used monies on his equity line of credit, he used monies, he took out monies, he put monies back in, it ended up being less than what it was on the date of filing. And that the judge failed to take into consideration. Goes on to say in paragraph 6,
but
that he's got...
You submit that implicit, I guess, in paragraph 5 is that there should be an adjustment made if the balances are reduced to less than they were on the date of filing.
It's got to be implicit because he's responsible for paying the obligations. And so if he pays these obligations down, he should be entitled to an adjustment. And I think if the court...
But I'm not sure I agree with that, because it seems to me that paragraph 3 says he's got an obligation to pay the debts. And then paragraph 5 says the balances of the debts on the date of filing shall be considered marital debts. So, I mean, it seems to me he has an obligation to at least pay the minimum monthly payments.
There's no question he had the obligation to pay it. There's no question that he had the accounts to pay it with also. In terms of whether he's entitled to paying it down, what would be the purpose, I guess, reversing it, of saying that the balances as they existed on the date of filing are the marital debts? I think the purpose was so that if you increased it or you decreased it, we're going to use this as a framework of reference as the beginning point. This is what we have agreed to utilize. Thank you.
Thank you very much, counsel. That concludes our cases for this afternoon.